The issues of money and politics have been around for a long time in American life. 45 years ago, I was a young ACLU lawyer, and I represented 3 people who were sued by the federal government under the brand new federal campaign laws for running an ad in the newspaper criticizing the President of the United States. The government's theory was these people had spent money to influence the election. It was 1972. Richard Nixon was the president. His Justice Department brought the lawsuit, and the campaign finance laws had to be complied with. So that was lesson number 1, that the campaign finance laws can pose severe problems for the First Amendment. Lesson number 2 was the Buckley versus Valeo case mentioned earlier. Congress passed an across-the-board set of restrictions on the funding of election campaigns, on how much you could raise, how much you could spend, how much independent groups could spend, required a broad and deep disclosure of every dollar that was given or spent, almost every dollar, and to put in charge of that a commission that was controlled by Congress. The fox being asked to guard the chicken coop. So that was my second exposure to campaign finance laws and First Amendment rights. And then more recently, of course, all of the issues surrounding Citizens United. And a law which made it a crime for every labor union in the United States, for every nonprofit organization like the ACLU through the zoology, Friends of Zoology groups, and every corporation, medium, small, or large, to run an ad speaking about a federal candidate during an election season. That too highlighted the difficulties and the problems of campaign finance laws and free speech and First Amendment rights. So that's my legal introduction, but more importantly, we have a terrific panel, a world-class panel to discuss these issues. And I will spend a moment introducing them. First is Professor Richard Hasson. He's the Chancellor's Professor of Law and Political Science at the University of California at Irvine, the author and editor of the enormously influential Election Law blog, a co-founder of the Election Law Journal, and one of the most highly regarded and influential election law specialists in the country. He is both an enormously prolific scholar of amazing range and depth, and an advocate who has worked on important cases and frequently advises legislative bodies. His views are decidedly pro-regulatory where campaign finance laws are concerned, as suggested by the title of his brand new book, Plutocrats United. Bradley Smith is Rick Hasson's counterpart on the deregulatory side of the ledger. He is the Josiah H. Blackmore II Shirley M. Nault Designated Professor of Law at Capital University School of Law in Columbus, Ohio. He, too, is a prolific scholar on campaign finance issues, including his highly regarded book, Unfree Speech, The Folly of Campaign Finance Reform. He is the founder and chairman of the Center for Competitive Politics, the nation's largest public interest litigation firm and think tank, devoted exclusively to defending and promoting freedom of speech and association in the political arena and public life. He also served for 5 years as a member of the Federal Election Commission. This is an encore appearance for Brad at Brooklyn Law School because he spoke at a similar symposium almost 20 years ago, and he reminded me that he was the first speaker at the first David G. Traeger Public Policy Symposium in 1997. And so we're happy he's making a return engagement. Our third speaker will be my colleague, Professor Sabeel Rahman, an honors graduate of Harvard College and Harvard Law School, a Rhodes Scholar as well. He teaches constitutional law and administrative law at the law school, and his academic research focuses on questions of democratic and participatory governance, public law, and economic policymaking. He's currently working on a book on these issues. He also is active in public life, serving as a special advisor to New York City Hall, a director of the Gettysburg Project on Community Engagement, and a member of the New York City Rent Guidelines Board. And of course, we're delighted to have our peerless leader, Dean Nicholas Allard, serve on our panel as well. Dean Allard has a remarkable resume, including a stint as a Rhodes Scholar, but I'm glad I got my tenure before being a Rhodes Scholar seemed to become a requirement of the job, but it's great. In any event, he has had an incredible range of real-world political and policy experience. He served as a top Senate staffer on Capitol Hill for Senators Daniel Patrick Moynihan and Edward M. Kennedy, and then as a Washington law firm partner and highly respected public policy advocate and proud lobbyist. He has written extensively about his political and policy experience, and he has operated in a world steeped in campaign funding issues and concerns. At the law school, he teaches courses in privacy law in a digital world and a government advocacy seminar. And I'm told he gets great student evaluations, and I'm sure that's true. He will be sharing his experience and his insights on campaign finance and governance with us. Each speaker will talk for about 10 minutes, and I may have to enforce that rule, and then we'll have a commentary. Thank you.
Well, thank you, Jill, for that introduction. It is a pleasure to be back. It's really great to be here. One of the great things is that I feel I have is I get to appear on panels now with people such as Judge Napolitano and Floyd Abrams and Joe himself, who I consider my heroes, and I'm also now so pleased to consider friends, and so it's a real joy to be here. I appreciate Greg Lukianoff's restraint during the earlier panel. The last time I spoke on a panel behind him at a symposium, he actually literally set off student riots with his comments, and we had to go through a mob of police and stuff like that, so I appreciate Greg's restraint if he's still here. Now on campaign finance. Virtually all scholars and judges recognize that campaign finance infringes on First Amendment rights, core First Amendment rights. You'll be hard-pressed to find any academic who argue that political speech is not at the core of the First Amendment, and I think it's fair to say that the substantial majority of thinkers and writers also recognize that efforts to prevent people from spending money to expand the reach of their speech infringes on the First Amendment. Just as limitations on spending money to build synagogues or publish Bibles would restrict the right of religion, or a limit on hiring lawyers, paying lawyers would infringe on the right to counsel. Over the past 40 years, unfortunately, virtually all academic scholarship in this field has been, except for Joel and I pretty much, has been devoted to explaining why these particular infringements on the First Amendment are somehow constitutional. Defenders of the First Amendment are few and far between, unless we want to count those who profess love and fealty for the First Amendment before urging its despoilation, like the husband who professes fealty and love before heading off to meet his true mistress. Our big topic here today is free speech under fire. And to understand the degree of the threat that campaign finance poses to the First Amendment, to free speech, we only need to look at both academic proposals that have been made and actual laws that have been enacted. I'm going to discuss just one from each category. Let's start with the latter. Modern campaign finance law begins really in 1974 when Congress passed amendments to the Federal Election Campaign Act that capped candidate spending at an amount far too low for a candidate to educate the public about issues, or for candidates without substantial pre-existing name recognition to reach the public sufficiently to have a reasonable chance of defeating incumbents or celebrity candidates. The limit for U.S. House races, for example, was set at $70,000. Additionally, the law limited citizen spending, the spending by us, to just $1,000 on all communications, quote, relative to a candidate, anything relative to a candidate. This law applied to political action committees, to individuals, and to groups like the Humane Society or the National Rifle Association. Unions and businesses were prohibited from spending money to voice any opinion in connection with an election, whatever that might mean. Another provision limited how much groups could spend or contribute for the purpose of influencing elections. And of course, almost everything that anybody has said here today might in some way influence the upcoming election. But they were prohibited from doing this without first registering with and reporting the names of their members to the government. Had this law not been struck down in Buckley v. Valeo, virtually all political information, including information on candidate records, legislative proposals, and more, today would have to be filtered through office holders, politicians, and through an exemption provided by statute in the law, the institutional press, with ordinary citizens as mere bystanders in our own political discussion. And even politicians would have so little funding, $70,000 for a House race, as to be almost entirely at the mercy of that institutional press. And yet Buckley has been under sustained assault for 40 years because Buckley struck down these draconian regulations on our political speech. Now let's take an academic proposal. Just 17 years ago, my colleague on the panel, Rick Hazen, proposed in the pages of the Texas Law Review that in order to guarantee equality, newspapers should be prohibited from endorsing candidates. Now, he was not alone. Others, such as Mark Tushnet at Harvard, my friend Ed Foley at Ohio State, have also called on limiting newspaper endorsements and other restrictions on the press. And there are other academics who have as well. Professor Hazen has backed off that part of his proposal, but so far as I can tell, he has not done so for any reason of First Amendment principle. He can obviously address that if I'm wrong on that. As far as I can tell, he simply decided that his empirical assumptions on which he relied at the time, that is, that such endorsements were influential and that they were skewed to the political right, were incorrect, and also that the political cost of such regulation is simply too high. The proposal just won't scour. At the core of the First Amendment, however, is a rejection of the idea that the government can sit about and decide who's too influential and who has too much political power. The reason Buckley has survived 40 years, despite 40 years of determined scholarship criticizing it, is that the case for reform on close examination simply isn't very good, right? The idea that the Constitution allows regulation, more regulation than we have now, which is more than we ever had before the 1970s, and in many particulars is more than we ever had before 2003, simply is not compatible with our traditional and historic understanding of the First Amendment. Beyond theory, the empirical case for regulation has largely failed on its own terms. There is simply little evidence that campaign spending and contributions cause corruption in the way that most Americans use this term, though many Americans mistakenly believe that to be true, in part because hundreds of millions of dollars have been spent to convince them of that fact. There is even less evidence that regulation improves public perceptions of government. In response to these problems, there has been in recent years an effort to redefine corruption in the most sweepingly broad terms. An effort that includes scholars such as Larry Lessig, Zephyr Teachout, and the aforementioned Robert Post. Their various definitions, redefinitions of corruption, in many ways amount to various equality rationales. And meanwhile, other scholars, and again my colleague Rick, have been much more explicit in saying we need to get beyond this narrow idea of corruption as justifying regulation and realize that the government should be involved in limiting speech of some in order to make us all more equal. But note that there is nothing new about this equality rationale. It's being argued with a new vehemence and emphasis, but there's nothing new about it. It was argued by the Supreme Court in Buckley v. Valeo. It was rejected there, and with the clear statement that the idea that you can silence some in order to enhance the voices of others is wholly foreign to the First Amendment, and it has been rejected many times since. It slipped in disguise into Austin versus Michigan Chamber of Commerce, a case that Floyd Abrams mentioned this morning, but otherwise it has not had much traction. And the reason is fairly obvious, because it is, again, no matter how much we try, no matter how much we'd like it otherwise, no matter how much there are certain people we really wish they wouldn't speak, giving the government the power to limit the speech of some to enhance the voices of others is pretty foreign to the First Amendment. And the First Amendment was intended to deny the government that power, and to deny the government that power because we cannot trust government not to abuse that power, or not to use that power as a cover for other goals, or simply not to adopt bad policies that in fact erode our democracy, such as, for example, a prohibition on newspaper editorials endorsing a candidate, or the 1974 BICRA amendments, right? Or 1974, I'm sorry, FACA amendments, Federal Election Campaign Act amendments. And it's worth noting that at some point, virtually every claim of every egalitarian theorist, from distinguished judges like J. Skelly Wright, to distinguished academics like Larry Lessig, to political candidates like Bernie Sanders, eventually come down to various declarations that if we are ever going to pass these particular policies that I favor, we have to limit the speech of the people who are opposing those policies. Now, Professor Hazen has long advocated for a voucher program. I don't want to address that. There are issues with that I think are probably insurmountable, but I'm open to it. But I want to address the idea of the limits that he proposes that should go with it. He wants to limit expenditures to $25,000 in any one race, to $500,000 total, although he's amenable to changing those numbers if you think some other number is better. And he says it won't really matter because, you know, the vast majority of Americans, the overwhelming majority of Americans, virtually every American, can't afford to spend that much, and that is certainly true. Now, let's leave aside that large spenders often represent large numbers of people. You can think of the anti-war millionaires who funded Gene McCarthy's 1968 campaign, or Ross Perot spending his money to make deficit spending an issue in the 1996 campaign. Or you can think about Ben Cohen of Ben & Jerry's flacking for Bernie Sanders socialism, right? Either way, we don't generally base government authority to limit rights on the number of Americans who might need them. The vast majority of Americans will never need a criminal defense attorney, they will never be subjected to a warrantless home search, and so on. Judge Napolitano's going, yeah, right, they're going to be subjected to a warrantless home. Yeah. He says, they're subjected to it all the time. Their phones are being searched. But they don't have the battering ram at the door, okay? Most Americans will never have trouble getting a voter ID or an ID to vote. But we don't just dismiss all these concerns with it. Well, they don't apply to most Americans. Most Americans don't care. 95%, 99%. No big deal to infringe the rights of the others. Unfortunately, the 40-year assault on academic speech has consequences that pose a threat to free speech even beyond campaign finance. Although it is true that the court tends not to have a fully unified First Amendment theory, it cabins off different areas of speech under somewhat different doctrines. There is no doubt that speech in one area, doctrine in one area influences doctrine in another, and more important for our purposes, attacks on free speech almost certainly undermine public support for free speech in other areas. Hence, we have the spread of overreaching campus speech codes and hate speech rules and passive acceptance of ever-increasing government surveillance and so on. We know from polling data that millennials, that our students who are here in the audience, are far less supportive of free speech than are the greatest generation, the boomers, or the Xers. And that should be troubling, at least to those of us who are in the substantial majorities of seniors, boomers, and Xers who have always had free speech high in our pantheon of values. If you have free speech still high in your pantheon of values, you should be aware that support for that is being eroded and being eroded quickly. And it is being eroded in part because scholars devote countless hours to arguing that free speech is a very, very bad thing in the most core area of free speech, which is talking about our political leaders. So, it's fair to say that this is carried over to a general atmosphere that people we don't like should be silenced, if not by law, then by mob action and physical, either physical or through the virtual world of virtual media. And that takes us back to the starting point. We all pretty much recognize that political speech is at the core of the First Amendment and that efforts to limit speech on politics, limit spending on politics, cuts at the core of these rights. And yet we've tolerated this assault for decades. These attacks on the value of political speech, whether framed as an anti-corruption interest or as an egalitarian interest, have a corrosive effect on support for free speech and society's willingness to tolerate dissenting or opposing views and society's openness to new knowledge and new ideas. Justice Brandeis famously said in Olmsted versus the United States, experience should teach us to be most on our guard to protect liberty when the government's purposes are beneficent. The greatest dangers to liberty lurk in the insidious encroachment by men of zeal, well-meaning, but lacking understanding. Even if political speech about candidates in government doesn't deserve maximum political or constitutional protection, I don't know what does. And this is ultimately the big threat to free speech of the campaign finance debate. Thank you.
Well, thank you very much for the opportunity to be with you today. I just want to take a moment and personally thank Joel. I've known Joel for a long time. Not only is he a brilliant scholar, and I learned so much from him, he's also one of the most civil people you'll ever meet, and always willing to engage in reasonable dialogue. And that's not true of everyone in all academic debates, and so I so appreciate you, Joel. And I'll pay it back by quoting from you in a few minutes. We'll see what we do with that. So I have a 35-minute presentation on my book, but I know there's no such thing as free speech here, so I'm only going to speak to one part. So this is the book, Amazon, 25% discount. So the main argument in the book is that for 40 years we've made a mistake in looking at the trade-off, the way the Supreme Court has framed it, between preventing corruption and the appearance of corruption and the First Amendment, the real important First Amendment interests of free speech and association. The court's views on what's constitutional and what's not have vacillated over time as it has expanded and then contracted the definition of corruption. There is a concern about corruption, but there's another issue that is equally important, and this is where the Supreme Court made the wrong turn, not in Citizens United, but 40 years ago in Buckley, by saying that political equality is off the table. And so I argue that we should stick with a balancing of First Amendment rights against societal interests, but the interest that we should consider is the interest in political equality, particularly the idea that we should not have a society of increasing economic inequality where we allow those economic inequalities to be translated into disparities in political power. Huge disparities in political power. So that's the main argument of my book. My book is divided into 4 parts. The first part sets out the problem, and I try to show the problem is not primarily one of corruption, at least in the narrow way that the Supreme Court has determined it, but one in which those who have wealth don't simply buy elections. We know that from the Jeb Bush situation. Money doesn't buy you Jeb. So what it does buy you is 2 things. One, it buys you more chances to have an influence over the outcome of an election, and the smaller the election, the greater your chances. And second, it buys you influence over public policy, especially over public policy for which the public is paying very little attention. For example, there was a story in the New York Times a few weeks ago about the 2,000-page omnibus spending bill, where Senator Harry Reid was instrumental in inserting 54 words at the behest of some lobbyists who were representing donors to his campaign, and that cost American taxpayers $1 billion. 54 words in the bill. So that's the main problem. It's a problem that money lets those who have the greatest wealth have the most influence over who gets elected and over policy. So that's the first part of the book. The second part of the book proposes a solution. The solution is campaign finance vouchers would give everybody $100 to donate to candidates, to parties, to interest groups, public funding through vouchers, which would more reflect public views, kind of an Austin view of proportionality. And I would couple that with limits, $25,000 individual limit, contributions and spending combined, clearly unconstitutional under Buckley, clearly unconstitutional under Citizens United. So this is my proposal, is to get to that point, and a $500,000 overall cap in all federal elections. So that's the proposal. Part 3 of the book are objections. I talk about 3: censorship, the press, and then a potpourri of objections, unintended consequences, polarization, political parties. And then the 4th part is how do we get there. The quick answer of how we get there is not a constitutional amendment, which would be either too draconian or ineffective, but instead changing the Supreme Court. It's much easier to amend the Constitution by changing a couple of justices than by changing the Supreme Court. This has become much more salient for the public. Now, the book came out a few months ago, but it doesn't take a brain surgeon to figure out we're going to have a lot of change on the Supreme Court, and it's potential that we're going to have a new progressive Supreme Court coming. And that, I think, is our only chance for change. So let me focus on the censorship objection. Let me read, I was just rereading some page proofs for a story I'd written about. So this is a quote from Joel that Joel was talking about the Buckley case. This is in something I was quoting Joel, where Joel's talking about the $1,000 limit, and he said the new law effectively silenced independent speakers in an unprecedented fashion. The ceiling was about equal to the cost of 1 quarter-page advertisement in the New York Times. Spend a dime more to express your political opinion and go to jail. Right? So this is censorship, right? This is how I take what Joel is saying. So I want to talk about one of the stories I tell in my book about a guy named Benjamin Blumen. Blumen's hardly seemed like a threat to American democracy, but a suit he filed called Blumen versus Federal Election Commission would have allowed the Chinese government or a large Russian corporation or Mexican billionaires to spend millions of dollars to get someone sympathetic to their interests elected to Congress, a governorship, or the presidency. Blumen is a Canadian citizen who went to law school in the United States on a student visa, worked as an associate at a New York City law firm on a temporary work visa. In 2011, he wanted to contribute to 3 Democratic candidates, including President Obama, print flyers supporting Obama's re-election bid, and distribute the flyers in Central Park. Under federal election laws, Blumen could not spend a penny. Congress had tightened up the laws that foreign nationals who are not permanent residents can't contribute a penny. So the Blumen lawsuit asked permission to engage in this spending. It was the brainchild of Yaakov Roth, a classmate of Blumen's who clerked for Justice Scalia, went to work for Jones Day. The suit followed both the playbook and the legal reasoning of the Supreme Court's Citizens United decision. The playbook: find a sympathetic small potatoes plaintiff to mount a First Amendment challenge to a major federal campaign finance law, a challenge which, if successful, would open up the door to much bigger actors. Blumen told the press, and this is what I thought of when I read Joel's quote, "It seems nonsensical to me that I'm allowed to go to Central Park and tell every person I see why they should vote for Obama, but if I go to Kinko's and I spend 50 cents to print out on a piece of paper the words "Vote Obama" and show that piece of paper to one American, I can go to jail for $10,000. I can go to jail for 5 years or be fined $10,000. Of course, reformers weren't concerned about Benjamin Blumen and his flyers at Kinko's. They were worried that if his suit was successful, it would open up the door for much bigger actors. The suit argued that under Citizens United that spending money on ads independent of a candidate can't corrupt the candidate, and therefore under the First Amendment, the government can't limit such spending. But Blumen failed. A 3-judge panel of a federal district court in Washington, D.C., led by Brett Kavanaugh, a Supreme Court shortlister, rejected the plaintiff's argument. The case went to the Supreme Court in a special procedural way that almost guaranteed the court would hear the case, but the court didn't hear the case. Without any argument, it simply affirmed the lower court. So what are the views of leading First Amendment zealots on this question? 2 of the 3 people I'm about to quote are in this room. Floyd Abrams, leading First Amendment lawyer. When I debated him on this issue at the University of Michigan in 2012, I asked him his view about Benjamin Blumen. I said, why limit Blumen's spending on campaigns if the Supreme Court is right in Citizens United that the identity of the speaker doesn't matter? Abrams' response was unconvincing. Quote, I do think that foreign influence is different than American influence. Maybe it's question-begging to say it, but I think different considerations come into play when we're talking about how we choose as a nation to allow foreign nations to play a role in our elections. Then there's Brad Smith. Brad Smith, despite his agitation for campaign finance regulation, was not at all bothered by the total and absolute ban on Blumen passing out his cheap flyers in Central Park. After the Supreme Court upheld the ban without issuing an opinion, Smith wrote on his center's website that, quote, well-known Lockean principles about the nature of political communities suggest that different rules might apply to persons who are not members of that political community, persons who are merely temporary residents. So Smith supports the ability of the government to strip a human being, Benjamin Blumen, of his right to spend 1 penny to support a federal candidate based upon a judgment made by self-interested legislators that Blumen is not sufficiently a member of the political community to have the right to speak about American elections. But he derides as censorship and incumbency protection a federal law that limits but does not fully deny the ability of non-human corporations to spend money in federal elections. Corporations, legal fictions that exist only by the grace of the state, are entitled to infinitely more political speech, as Smith defines it, than an actual human being living in New York. Self-interested legislatures can decide that different rules might apply to foreign individuals, but in Smith's view, they cannot make the same judgment about artificial entities such as corporations endowed by their creator with nothing like a human spirit. And then there's Jim Bopp, the Indiana attorney who's probably filed more lawsuits against campaign finance laws than anyone in the United States. He was the brains behind Citizens United and many other challenges. A strong opponent of abortion and same-sex marriage, Bopp is one of those no law means no law First Amendment absolutists when it comes to campaign finance, with one big exception. When the Supreme Court summarily affirmed the Blumen case, Bopp defended it. Quote, it is perfectly consistent for the Supreme Court to hold there's no compelling interest in prohibiting corporate and labor union speech, but there is a compelling interest in prohibiting foreign interests from contributing to candidates in U.S. elections. I, for one, this is still his quote, not me, I, for one, agree that the Red Chinese Army, the Iranian government, and Hamas can be prohibited from contributing. What's most ironic about Bopp's comments is that he supports the foreign money ban even though he's pointing out it's not viewpoint neutral. Bopp wants to shut up Hamas, shut up the Chinese army, and the Iranian government, presumably because of what they might say and how they might spend their money. So let's stop talking about censorship and start talking about sensible limits on campaigns. We all agree that some limits on money in campaigns make sense, and then the question is which ones. I just draw the line in a different place. And I think you can make a sensible argument that in making this balance, we can take very seriously, and I criticize the Reform Committee for not doing so, take very seriously the very important interest in robust political speech and in real competition elections, but still say that the Constitution is not a suicide pact, and we don't have to allow the wealthiest individuals who are spending literally over $100 million each, in some cases, to be able to have so much control over who is elected and what public policy we pursue. Thanks.
Great. So I'll add my thanks to Joel and to the Journal and to our co-panelists. It's been a great discussion so far. So we've heard a lot already, and we're going to hear more from the Dean. For my remarks, I want to step back a little bit and think about how we are conceptualizing the kind of democracy that we're trying to create when we appeal to First Amendment values and the role that speech and money both play in the larger democratic process. And by the time we get to the end, I hope that we'll maybe kind of approach some of these questions from a different angle. So one of the things about the money in politics debate is how prevalent the market metaphor is in questions about speech, right? There's an idea that more speech is good, and it's on the listener to decide what the truth might be. And you see the same kind of notion in context of political competition. It doesn't really matter how much money is spent or what candidates are up there, as long as the voter retains autonomy to make his or her own choice about candidate. And so there's a kind of consumer view about, or consumerist view about democracy, which is not just in the campaign finance literature. There's a deep tradition in democratic theory of a market metaphor in democracy, and it's the idea that as long as the voter retains the final sovereign autonomous choice, right, everything else is kind of fair game. And I think you see this in the Roberts Court, not just in Citizens United, but in their broader jurisprudence around the political process, which we can talk about more if people are interested. But I want to put pressure on this market metaphor in two ways. The first is, what happens when we flip from the consumer view to the producer view? And speech is not just about the expenditure or the ad, but there's a whole production process that goes into generating political speech. You have to raise the money in the first place, and that involves kinds of things that Rick was talking about. You've got, now it's not just the candidate or the donor or the spender, but you've got your bundlers, and there's a whole process around that. You have to have the ability to spend the money. You also have to have the ability to run as a candidate in the first place. And when you add all this up, the production function, if we use the market metaphor a little bit more, the production of speech, the production of democratic debate is not necessarily equal and not necessarily unproblematic, right? So that's the first challenge. A robust democracy, it seems to me, requires that we have equal opportunity to be producers of speech as well as consumers and deciders of speech. The second challenge is on this very separation of producer and consumer in the first place. So a lot of our discussion presumes, and empirically this is fair, that the people speaking are not really the main people deciding or voting, right? It's a pretty small number of people who are running for office or who are spending money on campaigns. But of course, the classical idea of a democracy is that to be a citizen means being both a speaker and a listener. Aristotle says that the office of the citizen is having the quality of being ruled and ruling, alternating between the two. Sharing in the business of government. So not just as a voter, but also potentially as a candidate, also potentially as a speaker, also potentially as someone in the public square. And the idea is that we as citizens play all, or ought to be able to play all of these roles in different parts of our life cycle as citizens. And so if we see that as a democratic ideal, the separation of the sociological separation of those who are primarily producers of speech in mass elections and those who are the voters, the consumers of speech, that is what creates the opening for the kinds of distortion, corruption, dependency concerns that I think are driving the worries of people like Lessig and Teachout and Rick. It's really sort of coming up in a context of this gap between producers and consumers. That the bigger that gap, the more opportunities for distortion in the process as you go from production to consumption. And it's not just in context of elections. So there's a lot of great new social science research kind of documenting these distortions. Political scientists Marty Gielenz and Ben Page have shown how if you look at the data, the likelihood that a policy that passes through the legislature that tracks the preferences of the voters goes up with your income. So to put it another way, wealthier citizens are much more likely to have their preferences reflected in public policy than less wealthy citizens. And I don't think that's literally because they give more money. In some cases it might be, but there are numerous different channels through which there is a disproportionate influence on the political process. There's another political scientist, Nick Carnes, down at Duke, who had this great study where he traces a lot of the changes in public policy over the last 50 years to the fact that there are fewer working class background legislators in elected office. So think about that for a second. The production of governance is not just speech, it's also who is able to run. If the people who are able to run are systematically no longer the same as the public as a whole, we have a problem as a democracy. Third thing I'll add here in terms of new research on different forms of influence is social and cultural forms of influence. So there's a law professor at University of Connecticut, Jim Kwok, writing about the financial crisis, shows how the shared educational backgrounds of financial regulation policymakers goes a long way towards explaining how deregulation came about in the first place. And this is a variation on the Carnes argument, right? That there's something sociological about when the people who generate public policy are no longer the same people as those who are the actual full body of the citizenry. So what all of this adds up for me in terms of the conceptual level is that when we're talking about money and politics and we're talking about speech and the role of speech in democracy and liberty, it seems to me that we also have to think about the speech not spoken, the candidates that don't run, and the items that are left off the agenda. And that those channels are harder to document, but just as real in their repercussions for our democracy. And that, to me, situates the money and speech problem in a much broader challenge of democratic responsiveness more generally. And so some of that, I think, is going to involve questions of the kind we've already heard about in terms of campaign finance reform specifically. But I think it speaks to a broader view of the First Amendment, and that the First Amendment is envisioning not just freedom of speech, but this broader democratic ecosystem where we as citizens are involved in all elements of the democratic process. And here I'm quite taken with Professor Newborn's poetic reading of the First Amendment, where I think he, and maybe we'll hear more about it today, but this idea that if you read the First Amendment start to finish, you actually have represented in it all the different levels of political engagement, the full cycle of being a participant in as a citizen, right? To think, to speak, to disseminate, to listen, to mobilize and associate, to petition and to advocate.
And to pray.
And to pray, yes, absolutely, that's part of it. But you add it all up and you now have, you see a free democratic society requires that we as citizens be able to do all of these things on equal terms with one another. So to close, I think this has been pretty abstract, but I do think it sort of suggests a couple of things on our particular topics of discussion. The first is, when we're talking about money and speech, I do think there's a strong case to be made for leveling up proposals that expand the set of who's able to speak, who's able to run, and who's able to set the agenda. So whether it's a voucher program or something else. But I also think it means that we need to look at the realm of civil society and associational life. So suppose for a moment you think that the rule in Citizens United about corporate speech is correct. Let's say it is. If that's the case, we then also need to think about what are other forms of association that we need to have a fully vibrant democratic process, not just corporations as associations. And the third is to think about what's the law that governs the political process between elections, and that shapes the way in which agendas are set and policies are decided. Some of this involves First Amendment, some of it doesn't. But I think when we're thinking about the fundamental nature of our democracy, we have to think about the First Amendment questions in this broader context of what kind of democracy we want to make and what it means for us to actually be full citizens and not just passive consumers. Thanks.
My assignment, as Joel described it to me, was to take this erudite analysis and discussion and bring it down into the gutter. And
Not quite.
to offer some practical perspectives on the topic of money and politics and campaigns based on my 30-plus years in the rackets, actually working in that area. To start off with some historical perspective, now you all know that Brooklyn is the center of the universe. And the very first, you may not know, some of you might know this, but the very first federal campaign finance law was the Navy Appropriations Act of 1867, which prohibited the practice of elected officials and appointees asking naval workers, the lower level Navy Yard workers over here in Brooklyn and other Navy yards, from having to pay back part of their salaries as a payback to the party for getting their jobs. So our scripture reading for my very brief remarks is Ecclesiastes 1:9, the prophet, there is no new thing under the sun. It's the conceit of every age to think, use the Latin phrase, oy vey. I've never seen anything like this before. And the fact is that in 1757, George Washington faced charges that he had rigged the election by buying off electors in his campaign for the House of Burgesses in Virginia with a massive banquet and boozer, which the records show included 37 gallons of wine and 35 gallons of hard cider, which seemed to tip him over the scale. He did win the election. Andrew Jackson started this patronage practice where people would be given jobs, party loyalists would be given jobs, but then they were expected to pay back into the party coffers. And then this was carried forward to the point where in 1867, first Navy workers were let off the hook, and then I guess in the Pendleton Act, everybody was left off the hook, and that was perfected with the Hatch Act. And then fast forward in the 21st century, we have a proliferation of campaign finance laws. So building off where we left off with the Buckley v. Valeo presentation, I think where we ended up was that if you're going to be talking about campaign finance reform, if you're going to be talking about the impact of money in politics, keep three things in mind. But the general overarching principle is one that was voiced by my friend and colleague Andrew Napolitano when he said, make sure that the cure isn't worse than the disease. And put another way, first, do no harm. And so number one is it's very important to be forward-looking. And so often I feel the debate on money in politics is looking through the rearview mirror. And when you're driving and looking through the rearview mirror, you can miss the turn or go over the cliff, either one. That's not a good thing. I'll just cite three examples of what I'm talking about very briefly. Number one is that President Obama was one of the first to be doing this, and now Bernie Sanders is doing this, and that is they are campaigning and fundraising in a new way using new media. A lot of the conversations are going on and talking about raising money for ads on broadcast television and radio, which are very expensive and so on and so forth. And that's where a lot of the money that's raised is going. Well, for whatever reason, but largely because the technology and new media now has scale, and people not only have the stuff, they know how to use it, you can see, and I was particularly bemused when Bernie Sanders, after, now I'm blanking, was it Iowa, where did he win, Iowa or New Hampshire? New Hampshire. So after New Hampshire that night, he said, in his acceptance speech, he says, and we're not going to be raising money from Wall Street, and if you like that, you can send a contribution, on BernieSanders.com, and he raised some humongous amount of money in a record period of time. So they have the ability to do that. And by the way, I think that that's actually a very interesting and a good thing, because the more you make fundraising democratic, and if everybody's contributing, you're beholden to no one, So it's kind of like not a bad trend. But so let's focus on the new techniques for campaigning and not the old techniques, the new techniques for fundraising. Second, there's a lot of assumptions about the evils of money, but it doesn't necessarily look like the huge amounts of money that are available correlates with the results. And I just cite, the Jeb Bush result as one example. So I think we have to really take another hard look and examine and try to document with good research. And try to measure exactly in a sophisticated way what the impact is of money on campaigns and results. And then the final thing is, that kind of end runs this whole money conversation, is free media. Trump is not paying for anything. I mean, he's paying money. He has the capacity to pay it. He's in a position because he's a very wealthy person. He's had the airways. But we have to look at it a different, and I'm not suggesting that money isn't involved in a way, but we have to be more sophisticated. So I watch, and I lose IQ points every day for this. I watch the Today Show every single day, right? And there's hardly a day when Trump is not calling in and on the Today Show for free, right? And so they're now, it's the ability, and Bernie Sanders, I think, has some of this going for him, and others do, but, you know, these old models that we're discussing aren't necessarily applying much. I'm not saying there isn't money involved. So, for example, for us to understand what's going on, it may be that it's deemed to be commercially valuable for the networks to carry that, to draw in eyeballs for entertainment or commercial reasons. And again, I have this nebulous idea this has something to do with the further blurring of what used to be a pretty sharp line between the news function and you know, the business function of broadcast media. Robert Korn Revere will have a much clearer idea about that and probably disagrees with me. But you know, I think there's money involved somewhere, but we have to look at it in a new way. All right, so the point is, though, that let's be continuously forward-looking and not come up with solutions to yesterday's problems. Second, let's focus on real problems. Now, my experience is that money is not corrupting. It is not, it is often presumed to be corrupting the political system. I mean, even if you tried to corrupt the political system with money, it's almost impossible. As one of my former partners, Senator John Breaux, said, you know, you can't buy the government, hell, you can't even rent it, you know, and it's too hard. It's not to say that money is not an evil or it has a problem, but I don't think we adequately understand the problem. There is always in these conversations, so frequently I hear, a presumption that money's bad, money adds up to undue influence, and that the whole system is rigged, and that's the problem, and then everything follows from there. I think we need a much more sophisticated understanding of how money has an impact. Now, there are recent really good studies on this. The Baumgartner, Beth Leach, and other studies out of North Carolina, the cross-longitudinal study about the impact of money on policy issues and so on over 4 decades, very impressive, and it shows that it does have an impact in a sense that it favors holding on to the status quo. It has an impact that often money is spent year in, year out, year in, year out, no change, and then suddenly there's a change. And their analogy is kind of like tectonic pressure that, you know, it's applying pressure, and then suddenly there's movement. But it's not exactly the direct kind of quid pro quo, linear type of result that people expect. And the, you know, other problem, so money is not necessarily the kind of problem it's assumed to be. So what are the problems? Well, money is corrosive in a lot of ways. I think it's been mentioned frequently here, but asymmetry is the problem. In a free speech context, if there's asymmetry in speech, I would always go for more speech and try to even up the sides in various ways, a lot of ways we do in our criminal justice system. You know, if it pays to have a lawyer, then in certain situations where people can't afford one, we try to provide them with a lawyer. It's imperfect, but similarly, I think finding ways and addressing ways to address the problem of asymmetry in resources and money should look on solving asymmetry by evening the score. Polarization is a problem. It's been studied and addressed, but a lot of the things that concern us and that we might attribute to money are a result of structural political problems. Joel and I heard Senator Schumer, for example, recently speaking about ways through changing the primary system, make an open primary system be one way to reduce polarization and get back to more of a consensus government. That's one idea, but there needs to be more attention to solutions to what are real problems, which is polarization is one example. Another problem, what I think, is that there's no governing. right? And there's no governing going on. It's all campaigning, all fundraising. So when I look at the problem of money and fundraising, it's not that it's corrupting, it's that it's keeping elected members from doing their jobs because they have to spend all their time raising money. So trying to find up creatively of ways to somehow curtail or end within our constitutional parameters the 24/7, 365 times 2 or times 4 or times 6, whatever your election cycle is, and focusing on creative ways to address that problem are more likely to be solutions than curtailing speech. The last issue that I think is a very, very difficult one that does not get enough attention is anonymity. And, anonymity is a double-edged sword. We want to have accountability, but on the other hand, sometimes anonymity is useful to protect people, not chill their expression of their rights, their exercise of their rights. But in terms of the political setting, I'm personally more inclined to have greater disclosure, greater identification of donors and contributions and all of that, and that's an area that I think bears a lot more attention. And for those that embrace the Federalist Papers and point out that even Madison J. And Hamilton signed their names as Publius, the real reason they did that, these guys were not afraid of signing their own names. They signed the Declaration of Independence when to do so was a death warrant, right? The reason that they did not sign their names was that each of them were making arguments of convenience to their adversaries to reassure them. So, in effect, and I'm grossly oversimplifying this, Hamilton is basically telling the states' rights people, the states are going to have all the power they need. And Madison, the ultimate states guy from Virginia, is basically saying, well, you're going to have all the necessary and proper authority that you really need. Anything that you need, the federal government's going to have. But they certainly didn't want to have that thrown back in their face after the Constitution was ratified to their name. And that's the reason why the three of them had a compact amongst them that the true identity of who signed the Declaration, the Constitution, the true identity of which of them authored which Federalist Papers was not to be disclosed until the last one of them passed away. Now, Hamilton, having a premonition of his own death and realizing that, given the predicament that he had found himself in, that probably the thing that he would be most remembered for until the play, right, was the authorship of the Federalist Papers, in a wonderful turn of phrase in one historian's book, ostentatiously hid in the book cabinet an annotated list of the Federalist Papers, which, by the way, he grossly overclaimed his own authorship, right? And the other two did not refute it ever. And Madison, when asked, they say, well, really, it's clear that Hamilton didn't write this. He says, well, I think he was under some emotional stress on his way to Weehawken that morning, so, he was very... And so that's the reason that's behind that. So I'm just giving you that anecdote that we should be very skeptical about anonymity and think very carefully about instances where having disclosure can serve purposes and generally transparency is a good thing. Okay, those are my notes. I'm going to end on that, and I really compliment not only this entire panel but all of the participants for hanging in here. We've been throwing a lot of information and content and thoughts your way, and I think it's just a great gathering here that we have today. Thank you.
Thank you. Well, I want to thank all of the panelists. I think they've given us a remarkable range of things to think about and issues to consider, and although we're not going to solve the free speech campaign finance regulation dilemma this afternoon, we've certainly been given a great deal to enhance our thinking. So thank you to all the members of the panel.